I'm Tim Hamilton, and this is the second in my series of videos to sort of help people prepare to appeal their property tax assessments. This video we're going to talk about preparing for the hearing, and specifically preparing if your house is being appraised using the market comparison method. There are four basic methods that are used in assessing property. Comparative properties, where they look at other properties that are similarly situated to yours and derive a value. 95% of people who get residential appraisals, that's going to be the method, and that's what this video is about. There's also what's called the MRA method, multiple regression analysis. That's a different video. Cost approach, where they try to look at how much it would cost to rebuild your house. That's a different video. And then also the income base, which is primarily income generating rental properties. So this one we're looking at what you do to prepare for your hearing if they're going to be using market comp. So I have my little sheet here because I can't remember all this stuff. The do's and don'ts. The first thing I'm going to go over is what you don't want to do at the hearing. The first thing is you don't want to go in and argue your taxes. Even though we know that your taxes are probably why you are appealing to begin with, that's a whole different animal. And if you say that, then they're going to ask you to go watch this video and kill 20 minutes watching a video on the difference between taxes and assessed values. Don't take the bait. You're there to try and develop a shared piece of information on what the value of your property is really worth. And I'm assuming in these videos that there is a rational, open-minded tax appraiser who's willing to listen to what you say and is willing to apply that so that you can come up with a shared piece of information. That may or may not be the case, but let's hope that it is. The second don't that we don't want you to do is don't take the burden of proof. Don't take the initiative. And what I mean by that is, it is under Kansas law, it is the requirement that the assessor initiate the proceeding and provide you with the information as to why they believe your property is the value that it is. It's a very common technique. In fact, I know in Jackson County, Missouri, I spoke with an attorney who explained that the appraisers in Jackson County, Missouri have been trained to ask a person when they come in, what do you think your property's worth? And you'll say, oh, my $300,000. Where do you come up with that? Well, you know, I'm looking at the various things that have gone wrong on my house. I have some photos here, and you can see the roof has fallen down at this particular area. Oh my, you've got a deck on the back there. We didn't know that. We need to probably raise that. Whoa, hold on now. Why else do you think it's worth $300,000? Well, you can see this photo here, I have a crack in the basement coming down this. Is that a finished basement? We didn't have you down for a finished basement. No, it's not a finished basement. It's just kind of a laundry room. And you see that the technique is to get you to start volunteering all this information that shifts the burden of proof to you to prove the value of your property. Kansas law protects you from doing that. It's a fair question, absolutely, to say what you think your property's worth. But in the don't section here, I'm saying don't use that as a launching point where you take over the burden of proof and the entire hearing is about you and what you think your value is worth. It should be about what the appraiser thinks their value is worth. And the third don't you don't want to do is talk about the change in the percentage increase. Now, in the previous video, I had you calculate that, and that's important information that you'll want to use maybe in the conclusion of your hearing, or maybe if you have to go to the next level of appeal. But the appraisers are trained to summarily discount that as an argument. Now, you and I think that probably is a very important piece of information. I think it's very important. There are constitutional amendments being proposed based on the percentage increase in value to sort of put a cap on that. Percentage increase in price is used in price gouging cases. So percentage increase is something that's used, throughout private and government industries around the country. But for this purpose, you're not supposed to use that. So put that one on the back burner and don't lead with that piece of information. The other thing you don't want to do is don't talk about an irrelevant property to the hearing. In other words, well, my sister has a house in this location, or my cousin has a house over here and he told me that he did this and that. That may be good for you to know, but in this particular hearing that chews up a lot of time. You don't want to do that. You want to focus on your property and the evidence in your property. So those are the don'ts. The things that you want to do, the first thing you want to do is write down what your questions are going to be. Write down specifically what you anticipate the appraiser is going to say, and then come up with a follow-up question to that, and then a follow-up question to that, which can be as simple as what a lot of reporters will do, is simply say, well, why do you say that? Or in this case, because a lot of this is going to be numbers, how did you get that calculation? Well, where did that number come from? Why did that number come into play? A common one will be when it looks at comparable values. Why did you select that address for that house? Why that house? And ask them, is that the same neighborhood as my neighborhood? That's a different neighborhood, isn't it? And a little key phrase that's used, they don't say neighborhoods, they call them submarkets. So you might say, hey, this house isn't even in my submarket. This house isn't in my neighborhood. Just kind of how the lingo goes. So the first thing you want to do, map out all of your questions. And this is something that will take some time. You might, a day or two later, think of other questions. Absolutely, put those down so you'll have your list of questions. The other thing you want to have are your exhibits ready, your evidence. And I break the evidence down into basically two separate categories. The first category are going to be photographs. Photographs of your property and photographs of other relevant properties that you think match your property, particularly if you disagree with what they selected as comps. You'll want to have those, and I'd recommend putting those photos with exhibits A through Z and just have a little chart that maps it out. That's what attorneys do all the time, and that's how they can flip to exhibit J and know right away what it is. So if you map those out, that won't take you but a minute or two to put those down, but that will help you be very organized, and then you'll be able to pull that particular photo up when you want to use it in the hearing. The other thing is I would want to have photos of what their comps are, which you can probably get off of Realtor.com or Zillow. Pull those photos off so that you can use them as a comparison to your photos. So, and I would label those AA through ZZ in the exhibit. So exhibit BB might be the kitchen that was remodeled in this comparable property. Exhibit FF might be the redone garage that was done in this comparable property. So all of those are the photographs of the comps that the county has selected as what they believe are similarly situated properties to yours. So after the photographs, the next thing down is going to be documents. So I want to have my documents in a separate section. And documents can be estimates. You've had someone come out and give an estimate for your roof, or an estimate to repair your flooring, estimate to fix your bathroom. Those kinds of things are going to be documents. The comp sheet that you requested, hopefully from the previous video, you've requested your comps from the appraiser. You might want to have statements from other people that have said various things. You might want to have statements from people. Any documents that you're going to want to have, you're going to want to have that in a separate sheet that is in your pile. So you have your photographs that are your photographs for your property, your side, photographs of what the appraiser has for their side, and then documents. So that's going to be your evidence. So that's what I would do in organizing for my first level hearing. The next video we'll talk about the strategies employed at the hearing. So see you in the next video.